Good evening, everybody. My name is Jim Hawk. I'm Executive Director here at Neighbor to Neighbor. I want to welcome you to another episode of the Neighborhood Passions Affinity Network presented by Google Fiber and Neighbor to Neighbor. I'm very pleased to welcome our new presenting sponsor of the Neighborhood Planning and Development series that we do. We are so glad to have the Housing Fund as our 2022-2023 sponsor. They're a great group of people, and we look forward to hearing from them in the very, very near future. Tonight, I'm very, very excited to have Elise Hudson here. Several months ago, everything flows with COVID, but several months ago, we started hearing about this lawsuit that was going on over at Whites Creek, and that there were neighbors that were daring to sue Metro government over a development issue. And it's really been a buzz. Every time I go to a group in Davidson County that's in contentious issues with Metro, they're like, what's going on? Is this something that we should do? I guess I want to say tonight as we start out, right? Neighbor to Neighbor provides people with tools, residents and neighborhood organization with tools that they can use. This doesn't mean that we're telling you you have to use them, right? But this is an opportunity for you to explore this tool, and it may be sometime in the future that it is right for you or for your neighborhood organization. But that's something that you and your neighbors have to decide. We're just here to talk about this tool and how it worked for Elise and the Friends of Whites Creek, so that you can at least have this background. So I'm very excited. Elise and I have known each other for a few years now, and our partner George, came to some of our classes, and we're really excited to have them both because they're so active in the Whites Creek area, in preserving and improving that place. And so tonight, I definitely want to give as much time as possible to Elise so she can talk about the suit that she was involved in. Elise, it's all yours.
Awesome. Thank you so much, Jim. And I am going to share my screen with my presentation. So let's make sure that this works. Okay, can everybody see my screen now?
Looks great.
Yeah.
Okay, great. So let me get adjusted here so I can see the chat pretty easily. So, all righty then. So just to kind of give you just a bit of an agenda for tonight, we're going to talk about the situation that led up to our lawsuit, kind of what that process looks like. I'm going to give you some tools that you can use at planning before a lawsuit ever happens. Give you the real down and dirty of what that meant to have the lawsuit. And then we're going to end on some of the things that are coming up that neighborhoods should really keep updated on as they're happening in real time right now at a council. So let's get started here. Just a quick introduction. So I was born and raised right here in Whites Creek. I moved away for college like a lot of people did, and now I am back. I was one of the founding members of Friends of Whites Creek, president currently of the Little Creek Community Club. So if you know where that is, over off of Old Hickory Boulevard and I-24, we're taking that over. I work for a company called Miro. It's an international software company. So I am lucky and burdened, but I have to travel to Amsterdam quite a bit. I ran for District 3 City Council in the council race back in 2019, only lost by a few votes, less than 100 for the runoff. So, and then I currently live in Whites Creek with Fergus and of course, George. And so I'll let George say hi for a second and introduce himself. Hello.
Hey, y'all.
Is he still there? You are.
I'm here. Hey, y'all. Thank you, Elise. I got to introduce myself a little bit earlier, but I'm Elise's partner. I enjoy Fergus. I live in Whites Creek. I have a background in computer work for Apple, and then more recently, my real estate license, but stay busy with community work most of the time. Thank you all very much.
Awesome. So I'm going to dive right in. There's a lot to cover. Like Jim said, there's a lot of this. This is really like detailed information that you may or may not have a solid understanding of. So please ask questions in the chat, or I'll try to pause at the end of each slide on the more technical kind of information slides to see if everybody understands or has any questions there. So the situation that led to our lawsuit was a proposal that's around basically our family farm over on Brick Church Lane. And back in 2017, we had received notice back when the notices only came within like 400 feet of when where development was happening. So I think our family was the only one that got the notice. And they wanted to build 200 houses in an area on a street. And if you're familiar with Brick Church Lane, on the east side of I-24, there's some industrial type things right near Brick Church Pike. But on the west side of I-24, it's rural farmland. There's only 20 houses today on Brick Church Lane. And the average lot size, I think, is about 16 acres per house if you do the average of all of our houses. What this would have done is put almost 7 houses per acre in an area that doesn't have, it's the general services district, it doesn't have any real amenities at all, and would have been a real shame. It wasn't the smart kind of development that we welcome and want in our neighborhoods. And so the proposal actually, the first time around, so it actually passed planning in 2017 when it first went to the Planning Commission. And so there's a couple of things that we need to talk through and kind of explain before I kind of talk about the actual lawsuit itself. And this will come up again later in how you can fight back at planning without having to get to this point, right? So there's really kind of 4 core things that the Planning Commission looks at when it's making an approval at planning. So if a subdivision or a development proposal comes up, the 4 things that they look at, for most part, are the zoning of that particular parcel. And that's basically the thing that determines the maximum amount of density that is available to the developer on that land. And so an example of that, I've got RS 80, which means that it would be a residential single family home on an 80,000 square foot lot. Or if you have something like an R6, then you've got a residential lot, but it's not limited to single family. So you could have duplexes, and then a 6,000 square foot lot. So there's, a whole slew of different zoning designations that you can have. And in the past, zoning has been zoning in the subdivision regulations we'll talk about have been the primary sort of thing that commission has looked at when they're making a approval or not. There are also Metro codes. So Metro codes are the laws specifically created by Metro Council. So some examples of that, if you've heard of the cluster lot option, that was in play here. So that was Metro code that says basically, even if you've got parts of your great big parcel that are unbuildable, the developer can still use the average number of lots across the entire parcel. Even if there are areas they can't build on, they can just then make that density deeper and higher, kind of to cluster the lots in an area on the parcel you can build on. So that was also applied in our situation. Then you have the subdivision regulations. So these are the regulations that the Planning Commission creates and maintains. And most of the time, if it's a residential development, you're looking at either the rural subdivision guidelines or the suburban subdivision guidelines. And that has a lot to do with like street frontage and cul-de-sacs, and there's just a ton of information and regulation in those documents. And then at last, which will be the core part of our lawsuit, the policy. So the policy is known by many names. The general plan for Nashville, this is Nashville Next, if any of you were part of that. Also, the part of Nashville Next that really applies when you're looking at planning can be also the community character manual. So there are a series of community character manuals that were built prior to 2015 when Nashville Next was approved. And it took, 3 or so years There was a ton of multiple community meetings and input that kind of the neighborhoods put into this plan before it was approved. And prior to our lawsuit, really planning had only used the policy in the situation where there was a zoning change on a parcel, and they would take that policy designation and look at the zoning designation that the person who had applied wanted to change to, and they would just kind of see, are they congruent, do they match up? And then the other thing that they would use the policy or Nashville Next for would be to determine whether an area used the rural subdivision guidelines or the suburban subdivision guidelines. And so when we went to planning to fight this, we basically were saying, hey, our policy says this, you should be taking this into consideration. And that didn't work for them. And we'll talk a little bit about the details of that a little bit later. So again, our original proposal from the developer was approved. And so we decided to file a lawsuit. So I want to give you kind of the legal basis for being able to file a lawsuit. It's pretty complicated, but there's a few good pointers. And so if you see here, there's 4 ways that the state kind of defines based on precedents of previous lawsuits and what the current law says, that 4 reasons that a court might get involved or be able to kind of overturn a ruling at planning. So that's if the planning department exceeded its jurisdictions, that means it did something it wasn't legally allowed to do, acted illegally, arbitrarily, or fraudulently, which is very difficult to prove. The standard of proof in the courts of law for this item are near impossible. You would basically have to prove some sort of insider fraud or bribery or something like that for something to get overturned. Very, very difficult. You can, in some instances, sue if the planning commission acted without material evidence to support its decision. Again, very, very rare that you're going to win a case based on that. It's really difficult to prove, has kind of the same standard as the acted illegally, arbitrarily, or capriciously. Some of the local law throws that word in. And so our attorney, Jason Holloman, and I'll give you his contact information at the end, we went after the proposal or the approval because we thought that Metro planning followed an illegal procedure. And so I'm going to walk you through kind of what that looked like. So I forgot to stop on my slides, like I said I was going to, but so I'm going to go back. Does anybody have any questions about these 4 things that the planning side uses as a guideline for when they make decisions?
Ian has a question.
Hey,
Okay.
thanks. Are these in any kind of an order? Is it like, the foundation have to go through this in its particular layers?
No. Hey, Ian, by the way, how are you? It's really not. I think that these are sort of any of these 4 things. If you can find a way that the development that you're there to kind of defeat, if that's usually the case, right? Or support, whichever side you're on. Really, if you can prove that it meets these 4 things and there's no example of where that development is outside or non-compliant with these 4 things, they really don't have any kind of leg to stand on to disapprove it. So you want to give them information on these 4 things. And we'll talk a little bit again about these 4 things before the end. Yeah.
Awesome, thanks.
And Dot, I saw your email, or sorry, your message in the chat as well. And we'll talk about that when we talk about the lawsuit in terms of how many hours and the time it took for this. And then, yes, we can make this presentation available and I'll get it to Jim so that we can get it out to everybody. Yeah. All right, so then back to this slide. So any questions here in terms of the legal basis for challenging planning decisions? Any questions there? Okay, and I'm going to get into the meat of our story and how this went down. So basically, during the planning hearing where this development was approved, the planning staff and the planning attorney, who are not voting members of the planning commission are all volunteers. I believe they're all appointed by the mayor's office, except for the one council representative who's voted as a representative from the council to the planning commission from the Metro Council itself, so a sitting council member. So the planning staff and the planning attorney were telling these volunteer planning commissioners, who generally defer to the experts or subject matter experts of the staff and Metro attorney, they have no reason not to, we're saying that the only way you could disapprove a proposal in front of planning was if it did not meet the subdivision regulations. So that our arguments about the policy coming into play and it not complying with the policy were invalid and not a reason to disapprove. Their argument was if it meets the subdivision regulations and there's no other major law that it obviously breaks, then the planning department has to rubber stamp approve it. There's no way that they have the authority to disapprove something like that. And if you remember what I said earlier, Nashville Next and the policy was the meat of the neighborhoods coming together and giving their input on the strategic plan for Nashville. And so those community character manuals have all this great detail about, you know, even in our instance, they called out the area immediately north of Briley Parkway in our community character manual and how it needed to be handled very sensitively, and there were no transition areas. And there were several other things in the policy that would have applied in this situation and been a justification for planning commissioners to disapprove. And again, they are generally the people who sue Metro over a disapproval or a decision are going to be developers who have a lot of money and a lot of time to spend on this, right? So they're not used to a lot of community organizations or community members challenging an approval. It's usually the other way around, where a lot of developers are challenging a disapproval. So staff is telling the planning commissioners, hey, you have to approve this. There's no reason we have from a legal basis for you to disapprove. So they reiterated that we're only allowed to use the community character manual in Nashville Next for zoning changes and figuring out which pieces of the subdivision regulations to use when making the decision. So if you look at the text of both Nashville Next and the subdivision regulations themselves, they both specifically say that in order for a proposal or a development to be approved by planning, that it has to be in line and compliant with the policy. And so basically you had their staff and a legal person, their attorney, saying, hey, Nashville Next doesn't matter except for these two situations. And we were saying, no, the law is written such that you have to comply with the policy. And if you think about it, Nashville Next was approved in 2015, and there was all of this like really detailed information, community members' time and effort that went into this. And basically planning since 2015 up through the end of 2017, when we filed our case and had our hearing, they had just been ignoring all of that for a couple of years and sort of set the standard of, hey, that's nice. It's a nice little document. We're only going to use these pieces of it. And so for everything that came before us, basically they didn't consider policy at all. And so our argument was that because the law in both the resolution that was adopted by council for Nashville Next and the subdivision regulations themselves say that it has to be compliant with the general plan and the policy, we basically went to court and said, okay, Planning Commission has basically approved this via an illegal process. And so luckily, Chancellor Anne Martin of our particular court agreed with us. And so we were able to, we won the first round, right? And so that first round took probably, we filed it in, I think, late November, early December of 2017. And then that first ruling came in January of 2019. So it took a little over a year, and that was pre-COVID, right? So that took a little over a year for us to get through that. So pretty quickly thereafter, the developers and landowners, which is interestingly enough, since 2017 up until the end of the story, they went through 3 different builders and developers with the same landowner. So it's a very complicated piece of property anyway. Lots of hills, lots of water issues, poor soils. It's right up against Briley Parkway and I-24. I'm going to show you just really quickly the picture again, so you can kind of see this is I-24 north being up towards Clarksville, and then this is the on-ramp to Briley Parkway where the FedEx facility is right here. And then this is the piece of property. So there's a cliff back here. There's a stream going through it. There's a TVA, high-powered electricity line. So it's just a complicated piece of property already, okay? So this next developer decided, okay, we're going to appeal. And when you appeal something, basically because it was a different developer and a different entity, there was a process that we had to wait for this new defendant, or new, I guess they were the plaintiff in this case, because we were the ones suing, to prove that they had to be part of, or had the right to be part of the court. We ran into a few sort of technical bumps along the road that extended the time for this and some of the attorney's fees. And so that took a few months, and then they went to the Tennessee State Court of Appeals. And so the State Court of Appeals took quite a long time. And by the time that it basically got to their docket, that was the beginning of COVID. So remember, because our first piece our first ruling came out in early 2019. It took a few months for them to get through, and then the process is just pretty slow. So at the beginning of 2020, right around like end of February, early March, we had another appeal, basically because the courts had gone to virtual only and not hearing oral arguments for things. So we had a whole other case and ruling based on whether we could have oral arguments or not. And what's interesting is that the plaintiffs and the city and the developer were arguing for those oral arguments so that they could come and talk to the judge in person. And the court ruled that there wasn't going to be an oral argument, that it would only be based off of these briefings or the paperwork that we had filed with all of the arguments and references in it. So after that piece came through, we finally, we're kind of on the list to be heard by the State Court of Appeals. It's a panel of 3 judges, which is different than the first situation, which was local to Nashville and only basically one judge. This was 3 different judges who took a look and had to internally, almost like a jury, vote amongst themselves and write a response. And they supported the previous ruling. So in essence, we won, but we didn't find this out until the end of 2020. So we got our final ruling in December of 2020 that this had been overturned. So yay, we won. What does that mean? So in a court case like this, when you're challenging a ruling, to win means that it's remanded back to the Planning Commission. So that means you just start over with planning. That's all that means. So then in late 2020, early 2021, yet this third developer comes up with a slightly different plan. But what we thought was not good enough plan based on the law anyway. And we went through several deferrals, and if you've ever been through that process, it's always very frustrating. But miraculously, we won. So the Planning Commission voted to disapprove the new proposal, which fixed a lot of the things we had pointed out to begin with, but in that time, we were able to do more research and find more specific laws, subdivision regulations, ways it wasn't meeting the code, the policy, and the subdivision regulations. And on top of that, now we had the policy on our side where we could say, hey, look, the policy isn't aligned with what these folks are proposing. And now we had a whole new tool to be able to kind of attack at planning. And so I'm going to go through what that planning hearing looked like once we won and when we had to go back. So a lot of information's there. And I will tell you it. So it has taken us probably 4 years, a lot of extra time with working full time and even with an attorney. There was just a lot of time and effort put into this, and cost us a lot of money. So this isn't the route for everyone, right? We were very lucky that there were a lot of us and we made it happen. I guess is kind of the, if you look at the et al on there, I think there's about almost 10 of us on the case that kind of contributed to this, from the Hudson family and George included. So what questions do you have from this piece?
It's Ian again. I'm wondering if the filing of the lawsuit stopped the process, like when you initially started and it was approved. Did the lawsuit stop the development in favor of waiting for a judgment?
George, I don't remember the first time around. Do you remember? I don't think it did.
What was the question again?
It did when we filed the lawsuit back in 2017. Did us filing that stop the developer from being able to move forward until the lawsuit was heard? I thought they could keep going.
I believe that they could, but it was concept plan approval. So they could not do final plan approval, which is an administrative action that happens within planning to then be able to turn dirt. So
Yeah.
The fact that the concept plan was approved meant that planning was going to move forward towards a final plan approval. With this case having been turned into a lawsuit that went to Chancery Court, there was not, with the understanding was that there would not be final plan approval until that was resolved.
So basically the short version of that is that technically the developer did have permission to move forward, but they knew it would be really risky. And when you're dealing with millions of dollars of infrastructure that they would put in, because they're going to have to put in sewer and lights and streets and all of that too, they didn't want to take the chance. And because they knew they wouldn't be able to get to that final approval, they sort of made a cost benefit analysis of not moving forward. But they could have come in and cut down all the trees and started moving ground and all of that. They just decided, because it was risky, not to, which I think is telling, because they knew we had something and they were really worried from the get-go.
Ray has a question.
Yeah, Ray.
Oh, you muted now, Ray.
I'm sorry. My question is, I printed a copy of Nashville Next because of the development that I fought by myself here, around the corner from me. But what is the CCM, and where can you get a copy of that?
Yeah, and so we can certainly get some resources and links out to you. I didn't think to put a resource slide together, but I can do that before I send the presentation to Jim to distribute. So the community character manual is a piece of the overall Nashville Next. So Nashville Next, kind of at its core, is basically, like I said, sort of that strategic plan for what Nashville overall needs to do and where the growth should be focused, so that the infrastructure is there to support it. Right. And then each neighborhood created a community character manual that basically, the community character manual is where the areas and the policies within your area. It's usually multiple areas. Like for us, it's the Hain, I think it's Bordeaux, Whites Creek, Haynes something now. They've changed the name of it, but lots of neighborhoods all together. And that specific community character manual has even more detail about that neighborhood and which parcels have, or which general areas have what policy and why. And so that community character manual, if you Google Nashville Next, you can usually kind of navigate through like the text of Nashville Next. And there's a link on that site that's pretty obvious that says community, link to the community character manuals.
Okay.
It's usually, I think it's broken out by chapter, and each is a PDF because they're very large and lots of graphics and that kind of thing. But we can certainly get you a link to the page that lists all the community character manuals.
That link is actually in the chat room now.
Perfect.
Oh,
Thank you so much.
Thank you very much.
I'm ready.
Yep. Hi, Ray.
We sort of had to, I live in Highland Heights, and we, our former council person had made a lot of deals without consulting the neighbors or the neighbor association or whatever. So to make a long story short, we had to go to the planning commission and change policy. And we did that by demanding a charrette. And it was a week-long thing. Our group, a lot of folks from our neighborhood participated in it. And it worked to the extent that we, now developers don't even come to us or go to commission before they come to us. And if they don't receive, approval from us, then they're really stuck. Now what's happened is a lot of the stuff that was done before we got the new council person is now coming to fruition with these huge builds in 1 square mile. And, you know, with no context about the water, you know, we've got underground creeks running in our neighborhoods, and it's built on a hill and everything's flowing down. So we're now in the process of trying to deal with a lot of new folks that want to build, and they are bringing in, I mean, we had a meeting last Thursday, and there were more developers there than there were people.
Yeah.
And none of them, they presented their case. They even had the owners and the attorneys for the owners. Of course, we wouldn't allow them to talk because they didn't live in the area. They lived out of state.
Right.
So little by little, we have gotten the commission to recognize that unless they get approval from the neighborhood association, they will not even they will not even accept a case. And that's how we dealt with it. Now, I imagine we get a new, you know, people will get stronger, or if we get another council person, of course, in 4 years, that may change. But it's really been a real interesting learning experience to know that you can change policy if you just keep pushing, and you got to show up in mass to these hearings.
Yeah.
You know?
And we actually tried to do that. So after the first case, or the first round of our win, basically, we did try to change the policy on this area because there's, and this gets really nerdy technical, so bear with me, the transects, or the policy types that are defined in Nashville Next, this particular piece of land was listed under T3NE, which was suburban policy moving towards urban policy, which doesn't make any sense. And all of us were fighting it through the Nashville Next process. And what's interesting is former Councilman Walter Hunt lives across the street from this development, or where this development would have happened, kind of back up Trail Hollow. And he was not only our council person then, but he was also the council representative to planning. So he had a lot to do with Nashville Next in some sense of getting it passed. But the policy kept changing. So we went back to try to get a policy change, because the version of Nashville Next that got approved, there was no T2 version of neighborhood evolving. So there was no T2 rural evolving to suburban T3. It was only the suburban moving to urban, and they thought it'd be easier if they just combined them. But it's obvious that before the Nashville Next was even approved, they were thinking it's not going to matter. We're not going to use it anyway. Right? Well,
we were able we were actually able to reverse the zoning, because they had brought into the neighborhood core the evolving stuff, and they put in 2 houses in lots and stuff. Well, then they were trying to get 3 in a lot. And what we managed to do was to actually get the zoning changed for a big portion of the inner part of our neighborhood. And it's only, it's only on the perimeters that they're allowed to build like that.
Yeah, and so we had a huge thanks to George, who did a lot of the legwork. After this was done, we did a large zoning change. Unfortunately, we couldn't get the zoning on this particular parcel change because the owners didn't want it. I've got a whole lot of questions in the chat, so let me get to those. Grace, you asked why we picked Jason Holloman, and I will be honest with you. Back then in 2017, nobody thought we would win this lawsuit. And so we had multiple attorneys turn us down, and someone recommended that we talk to Jason Holloman, and he took the case and we won. So that's the other thing, that if you choose to go this route, some of these attorneys, most of them are bankrolled and most of their clients are developers.
Right.
And so we found that very much to be the same case if you wanted to find a civil engineer to take a look and to challenge any of the plans. You can't get a civil engineer to, even if you pay them the exorbitant rates that they charge, they won't let you hire them if you are a neighborhood person, because they don't want to ruin their reputations with the developers. So I'm going to keep going. Ray, I think I answered your question. We'll get you the link. It's in the chat for how we find this CCM. Dodd has this policy. Oh, so there's actually, so Dodd's been in law class in grad school and has some information there. So thank you for that comment. Yes, so Grace, you're right. It was going to be like, you have to have, I think it's $1 million bond to have an injunction. It's just not feasible for a neighborhood group unless you're super rich. Dodd, it was spread out over the cost of the case was spread out over quite a long time, and luckily we were just able to manage it over time. So I think, you know, the idea is ideally you would be able to have a nonprofit set up in your organization that could do some, you know, 501c3 fundraising that could be used for these types of things. So that's where we'd ultimately like to get to, but it's a lot of work to get that designation. So we were just privileged, honestly, which doesn't help anybody else, but we were able to do it. So. Then we've got the link, and then George kind of was pointing out some other things, and then no. So in a legal case like this, where you are basically challenging from the Planning Commission, there are no fees covered when you win. So it's not like a civil suit or a criminal suit or anything like that. There's no restitution. There's no, okay, we won. Well, you know, you won, therefore the other side's going to cover your legal fees. It doesn't work like that in the Chancery Court for this process. So unfortunate. So I do have a couple more slides that I want to get to, and I know we've only got about 10 more minutes in our allocated time. I can stay after to get through some questions for a little bit. So don't think I'm going to run away right at 7:15, but I do want to keep going because I got about 3 more slides I want to get through. So some tips for the neighborhoods at planning. So like I said, these 4 components, these are the same 4 components that I brought up earlier of how planning makes these decisions. And I cannot stress enough, you have to be void of emotion as much as possible, or somewhat deferential to the Planning Commission when you are there speaking in front of them, and state the facts. You can go through and point out and quote parts of Nashville Next, quote the policy, Metro code, subdivisions, and safety, and I messed up my triangle because zoning is supposed to be in the middle, not policy. Nashville Next are the policy, so I'll fix that before this goes out too. So, you know, there are lots of detailed, crazy laws out there that you can read. It's hard and it sucks, and then you need like lots of people to ask questions of, but it's out there for everybody to see, and we can get you links to all of these things, and you just sort of get familiar with them when you start going to planning and have to go through this process. So if you go up to our presentation, we made a PowerPoint deck and put a binder together with tabs for each of these 4 things that said, here's why it doesn't meet the code, the regulation, the policy, the cluster lots. Here's why there are safety issues. So there is actually a part of the subdivision regulations that talks specifically about the safety of residents in the community. So if you can pull up a big problem like the Nob Hill residents did with the TV tower and ice and freezing and just sort of this dangerous situation where they were going to build houses right up against there, they won their fight against the developer in that case because of safety issues. So we had several safety concerns, including there's no embankment, or like there's a torn down, rusted old chain link fence between I-25 70 mile an hour and where these houses were going to be with not much buffer. There's a cliff on the back of the property. There were poor soils. There's a 7,000 volt electric fence, security fence across the entire southern perimeter of the lot, right up against FedEx. That would have been, you know, the backyard of some of these houses, and right up against a water retention stormwater pond. So we had lots and lots of concerns about safety from the community that can really help move some of that as well. So I'm going to keep going because there's two more really important things I want to talk about. And so as expected, right now that we have the Hudson et al. Ruling, and planning and including some of the folks on the Planning Commission today are very keen to start disapproving some of these less responsible developments because they have the tool of policy to be able to do that. And legally, they have to make sure that it's applied and everything's in compliance. So we have found, you know, you can kind of always see which side of the tracks that some folks are generally on. Some folks on commission are pro-development, some folks are pro-community. But if you can give them the specific tools, there are a handful of folks who are just, they will vote in your favor against any irresponsible development if you can give them the facts that substantiate that to make it so that they have real reason to have made that decision. And so right now at council, I think on first reading this coming Tuesday is a new resolution that, ironically enough, our council person is a co-sponsor of and has introduced. That is, the number is there and we'll make sure you get the information, but it's a resolution requesting that the Metro Planning Commission and Planning Department review and amend as needed the current general plan for Nashville and Davidson County, Nashville Next, to general plan no later than June 30th, 2023, in the middle of a pandemic. Right. And so this is a very dangerous bill. There's a lot of legal questions about whether a resolution from council can actually make them do it or not. We're trying to figure out what this means. But if this goes through, then basically what they're asking is to reopen and change at any point, any part of Nashville Next. And if you, I'm not going to name names, but some of you on this call are very aware. You can look up your council person and who has donated, what groups have donated to that council person, and it will tell you a lot about what their political stance on development is. And I think this is going to be a big deal because now that there's this wide, very pro-neighborhood ruling that anything within the policy that isn't met by developers can now be a reason for rejection. The developers are all out for Nashville Next at any cost, right? This is costing them money. They want to just like build houses as cheap as they can and get out and make their money and go. And this is a big, big hurdle for them now, which we're very proud of, but it goes to show how vulnerable Nashville Next is now that we've got the Planning Commission doing what they should have been doing all along from a legal perspective. So keep this on your radar. The second reading is when public hearing is, and that's when we have the ability to go and speak on this. I don't think they're still doing dial-in at the council meetings, so unfortunately that means going in person. You can send emails, but we'll make sure that everybody gets that information on this list and give you a link where you can kind of track what the next meetings are from the legislative site. So here is our contact information. And so I know we've only got 3 minutes left, but like I said, I'll run long and start answering some of our questions. And if any of this sort of didn't make sense, or you want a deeper dive on planning and that sort of thing, I do want to make a shout out for the neighbor to neighbor 101 and 201 courses for planning. So Jim can give you information on that, but they'll go into this in a much more detailed way than I've been able to do in 45 minutes. All right, so how about Dodd, let's connect after and make sure we have each other's contact information. So I saw your message, and let's see, great. Yep. The bill number for that, Grace, it's in this spreadsheet or on the PowerPoint. So Grace asked if we had the bill number, so we'll make sure that's on that. Raphael, you said that the resolutions don't get 3 readings like bills. How does it work then?
A resolution gets read the one time and it's either passed or it's not passed. And sometimes it's on consent, which means they all just get passed. They don't even get discussed.
So it is on consent for first reading for this Tuesday. So that means we need to get that information out.
It's just one reading.
Okay, we're gonna look into that and make sure that that's out there. So then everybody.
What you put up, excuse me, I'm sorry.
Go ahead.
A resolution number. Yeah, resolutions are not like bills. They don't get 3 readings. They just go on consent.
Okay, well,
some resolutions
then
get discussed if they want to talk about it, but it doesn't necessarily. It's not like a bill.
Okay,
and I
well, then I'm going to have a very busy weekend.
Visit Nashville Next before this.
Yeah. Well, and it's also very important to reiterate what you and Ray have also said in terms of there is already a mechanism in Nashville Next for communities to revisit particular policy and areas, and they can get that charrette from the Planning Commission if they all come together in mass, like she said. And so that's already built in. I mean, this is just a very obvious grab from developers, unfortunately, to try to change and react to our lawsuit, unfortunately. So let's see here.
Hey, Elise.
Yeah.
I'm going to butt in just for a second here.
Sure.
Commercial break while you're reading those chats. We're going to continue this for a little longer, but some of you may have to leave, and that's okay. It's understandable. I did want to just bring up 2 important things. We did put in a little bit ago, but I'll put it in real quick right now. For those of you who want to learn more about the planning and zoning, policy and zoning, we do have policy and zoning 101 and 201 as part of the Planning Academy. There's a link now in the chat. I also want to talk, because we're going to announce it tomorrow officially, but we're getting ready for C4N Nashville 2022. And this year we're going to focus on 5 major issues, not D5, but 5 major issues facing our neighborhoods today. And we're going to spend each participant will get to spend a whole day focused on one of those issues. And one of those issues that we're going to be talking about is responsible development. And how do we create a city that operates using responsible development? And it is going to be a highly interactive discussion. And I really hope that each of you who are on here tonight will register for C4N and participate in that conversation because we've got to move forward. And one of the nice things about C4N is when neighborhood leaders come together like they are tonight, we get a chance to really have conversations about how we can all work together to create change. And so that is an important component. So I hope you'll join us for C4N Nashville 2022 on Saturday, April the 2nd at the Music City Convention Center. And now back to you, Elise.
Yeah, I was just going to post in the chat, please, if you have access to neighborhood email lists or contact lists for your groups in your neighborhood, please forward the information about that particular bill so that we can get this. If it's really going to be, I mean, currently it is on the consent agenda. If they're really voting on it on Monday, then we have a big problem and we need to act now and email all of the council, your council folks, and the at-large. And if you have the list of all of the council, please get the word out. The more that we have opposition to this, the better. It really will cause us all great amounts of pain and heartache and stress if they open that back up and change basically everything that's protecting us today. So, any other questions about the presentation? Billy, hi, go ahead and unmute yourself and.
Let me get unmuted. Okay. This is great information. You've done a great job here. I'm going to switch areas on you here a little bit. Most of these comments have been about the community, and that's appropriate. Community should have input into this. I'm going to talk about from the viewpoint of the property owners. And I'm going to do that a little bit. I'll do it best by an example. I hope I condense it here. Let's assume that a property owner has some land and it's classified by Nashville Next as industrial. One of their class or specific plan or something like that. It's industrial. It's currently zoned residential. Now that property owner has a developer who wants to develop that property with some warehouses, a couple of warehouses, whatever. Using this case, as I understand it, it can be a part of our, if the planning department refuses to hear it, we can use this case to kind of force them to do it legally. Now, my question is, if the council member will not support it, are council members subject to the same set of laws as the planning commission?
No, because they're council members and they have a separate one, but some, yes. So there's a couple of things I need to kind of ferret out from your question. So there are parts of the Nashville Next policy that you could probably look at the community character manual and look and see if they've called out this area specifically. But I know in some of the major transects it talks about, and George may know this better than me, it talks about how industrial is not appropriate to be bordering residential. And so there's some of that, but I don't understand necessarily the question in terms of, is this a rezoning? Is this just a concept plan that's going in front of the planning commission?
It would require rezoning for the developer to construct these warehouses.
Yeah. And unfortunately, the council person.
From what I understand about this presentation is, if the planning commission refuses to hear it because whatever reason, well, they say it won't fit the Nashville Next plan or whatever, I'd have something I could sue the planning commission on.
So not necessarily. The rezoning is a completely different beast. This was just a concept plan ours was just a concept plan using existing zoning and existing policy. And so when you have a situation where there's a zone change, if your council person supports that zone change, there's not a lot you can do but start reaching out to that council person and the other council people, your at-large council, and see if you can get some opposition to it. I'm assuming you're opposing this, but
no,
what happens
in this situation I'm talking about, the council member would not support the rezoning, even though Nashville Next had it classified as industrial.
So then, unfortunately, I don't think that there's anything that you can, at least that I know of. You probably need to speak to an attorney who knows a little bit more than I do, because if your council person, the council folks, and this is what most people don't understand, I know I'm preaching to the choir with this crew, but council really drives a lot of power. They have a lot of power when it comes to rezoning, because if planning disapproves a rezoning request, it still goes to the full council for votes. It's just that they need, if they get approved at council, they need a simple majority. If they go, if after it's been disapproved at planning, then basically they need 2/3 of the council to approve for it to pass. And the council folks don't like to vote against each other when there is a particular parcel that's completely enclosed in their district, because they don't want the other council people to challenge their rezoning efforts. There have been instances where something's just so egregious or crazy that the council doesn't let it go through. But for the most part, if your council person either wants a rezoning to happen or doesn't want a rezoning to happen, it's in their control. And that's why these council races are so important.
Thank you.
Yep. Yeah, any other questions for today? Okay, well, thank you so very much. And again, I just really appreciate everyone coming and being interested. You know, I posted my contact information in there. George posted his email earlier. Thank you so much for being here, and hopefully this will help you in your struggles. Please use us as a resource. We're not attorneys. We've just been through a lot. So there are certain things that you would definitely want to double check, like George says in the chat, about how things work. But good luck in your fights, and know you're not alone, and know that there's hope on the other side, and that what we do matters.
Elise, thank you for this excellent presentation. Very thorough and very clear, because that was a lot of material to cover, and you helped us to understand it. So we really appreciate it. Thank you very much for your time, for your energy, all the stuff that you're doing. Please know that we meet every Thursday night at 6:15 p.m. Each week we focus on a different topic. If you are not on our digital newsletter, be sure to sign up so that you hear about the next topic. But come back each week. There's always something good to discuss. And let me just say, you are what is great. I'm looking at you. You're what's great with Nashville, right? You are what's beautiful about Nashville, because you take the time and you have a commitment to really take care of your neighborhood. So thanks from the bottom of my heart for all the great things that you're doing in your neighborhood. We will see you next week.
Jim, one question
you.
before you go.
Oh,
I got on like 2 minutes ago
she
because
can't
of all the
repeat-
traffic
she
on
can't repeat the
I-65.
presentation. She can't repeat the presentation.
That's my question. Where should I go, and when should I go to see what I missed when I was sitting in all that traffic?
In 7 to 10 days, our editor will make a beautiful video out of this, and it will be back on our YouTube channel, and it will be on our website. And if you get our digital newsletter, you'll be able to get a little notification that says this presentation is available. Ian.
Thank you.
Hey, thanks. A quick note, there's a District 1 United meeting on Saturday for anyone who's a stakeholder in District 1. It is the community responding to a breakdown in communication. We're meeting with the vice mayor and at-large. Email district1united@gmail. District1 United, that's spelled out, District ONE United@gmail. And I will send you the Zoom link and information about that. If you're a stakeholder in what's happening in District 1, please come on Saturday and speak your piece. Thank you.
What time is that again, Ian?
Thank you so much. That is noon on Saturday.
Okay. All right. Thank you.
All right, everybody. Go do beautiful things.
Don't forget to send out emails about the resolution.